This is going to be simple. It's going to be very simple that even an FBI director should be able to read it. This is the Espionage Act I talk about over and over again. She violated the Espionage Act of the United States, Section 793 of the United States Criminal Code 18. And that's what she did. Not once, not twice, but multiple times. And we know this because FBI Director Comey told us this. Now let's look at the statute as written. 18 United States Code, Section 793, gathering, transmitting, or losing defense information. This involves national security. It's called the Espionage Act. Whoever being entrusted with or having lawful possession or control of any document, writing, code book, signal book, sketch, photograph, photographic negative, blueprint, plan. They're obviously trying to be completely fulsome in their description here. Blueprint, plan, map, model, instrument, appliance, note, or information relating to the national defense. Next. 1, through gross negligence. Not intent. I've pointed this out 1,000 times. Not intent. Not specific intent. Gross negligence. Like if you're extremely careless, let's say. Gross negligence permits the same to be removed from its proper place, from a protected government server or protected email to a personal unprotected government server, whether you receive it or send it, or just keep it there. To be removed from its proper place of custody or delivered to anyone in violation of his trust, or to be lost, stolen, abstracted, or destroyed. Or 2, having knowledge that the same has been illegally removed from its proper place of custody, a secure place of custody, next chart, or delivered to anyone in violation of its trust, or lost, or stolen, abstracted, or destroyed, and fails to make a prompt report of such loss, theft, abstraction, or destruction to his superior officer, shall be fined under this title or imprisoned not more than 10 years or both, for every single count. This applies to everybody in the federal government. Everybody. 2 million federal civil servant employees. It applies because the reason is they want to protect security information. And we learned and we knew that she had access to the highest types of classified secret information. And not just one piece, but many pieces. And she told the American people she didn't. Now, we're going to listen to Comey, but we're going to do it the way we do it here on Levin TV, where it's not done anywhere else. I will break it down as we go through it. The statute that was passed by Congress and that everybody else in the federal government, political or non-political, has to live under, it is gross negligence. People are violated for gross negligence. Not intent, even though I would argue there's intent, but it doesn't matter. We don't have to argue in the alternative. There it is, gross negligence. Back to the video.
The handling of classified information. There is evidence that they were extremely careless.
Stop. So number one, we know there was classified information. Number two, we know some of it was top secret. Number three, we know that it was, what was the phrase? Extremely negligent. No, extremely, help me somebody. Careless. Go.
In their handling of very sensitive, highly classified information.
Hold on a second. Highly classified information. It's hard to see what you're writing, you know. Go ahead.
Example. 7 email chains concern matters that were classified at the top secret special access program at the time.
Stop. Special access program means even people who are cleared for top secret can't get the special access program. It is a small, tiny fraction of a percentage of people in the federal government who have that clearance. That is a big deal. That is a big deal. Go ahead.
Sent and received. Those chains involve Secretary Clinton both sending emails about those matters and receiving emails about those same matters. There is evidence to support a conclusion that any reasonable person in Secretary Clinton's position or in the position of those with whom she was corresponding about those matters should have known that an unclassified system was no place for that conversation. In addition to this highly sensitive information, we also found information that was properly classified as secret by the U.S. intelligence community at the time it was discussed on email. That is, excluding any later up-classified emails. None of these emails should have been on any kind of unclassified system, but their presence is especially concerning because all of these emails were housed on unclassified personal servers, not even supported by full-time security staff like those found at agencies and departments of the United States government, or even with a commercial email service like Gmail. I think it's also important to say something about the marking of classified information. Only a very small number of the emails here containing classified information bore markings that indicated the presence of classified information. But even if information is not marked classified in an email, participants who know or should know that the subject matter is classified are still obligated to protect it. And while not the focus of our investigation, we also developed evidence that the security culture of the State Department, in general, and with respect to the use of unclassified systems in particular, was generally lacking in the kind of care for classified information that's found elsewhere in the U.S. government. With respect to potential computer intrusion by hostile actors, we did not find direct evidence that Secretary Clinton's personal email domain, in its various configurations since 2009, was hacked successfully. But given the nature of the system and of the actors potentially involved, we assess we would be unlikely to see such direct evidence. We do assess that hostile actors gained access to the private commercial email accounts of people with whom Secretary Clinton was in regular contact from her personal account. We also assess that Secretary Clinton's use of a personal email domain was both known by a large number of people and readily apparent. She also used her personal email extensively while outside the United States, including sending and receiving work-related emails in the territory of sophisticated adversaries. Given that combination of factors, we assess it is possible that hostile actors gained access to Secretary Clinton's personal email account. So that's what we found. Finally, with respect to our recommendations to the Department of Justice.
Let me interpret this to you, for you. I'm not very good at this. I was never a teacher. Although as a kid, I used to put chalk in the eraser, but that's a whole other story. Highly classified information, that comes out of his mouth. The highest of highly classified information, even on a few occasions, including top secret and beyond. Extremely careless, to me, extremely careless means gross negligence. There's really no difference. That would be a phrase that is a synonym to gross negligence. He's saying a reasonable person standard would know sending and receiving this kind of information on personal, unsecured servers is illegal and might be accessed. He's also saying that the State Department, the entire system, when it comes to security and following the security measures, is very lax, it's weak, it's sloppy. She was the Secretary of State. Did the enemy access it? He comes as close to saying yes as you can possibly come. He said he thinks they did access her personal accounts because they're unprotected. They're unsecured. He also goes on to say she used these unprotected, unsecured accounts while in hostile territories, and they possibly were accessed. So let me put it in plain English for Mr. Comey, who doesn't want to go there. She violated the Espionage Act, and the enemy got access to information. That's what he won't say, but that's what he said in the last 15 minutes as he dances around this point. It's a very thorough discussion, yes, I admit, but his conclusions are very careful because he doesn't want her indicted, for which she should be indicted, on multiple levels. You can see. Go ahead.
In our system, the prosecutors make the decisions about whether charges are appropriate based on evidence that the FBI helps collect. Although we don't normally make public our recommendations to the prosecutors, we frequently make recommendations and engage in productive conversations with prosecutors about what resolution may be appropriate given the evidence. In this case, given the importance of the matter, I think unusual transparency is in order. Although there is evidence of potential violations of the statutes regarding the handling of classified information, our judgment is that
there is evidence of potential violations. Now, he knows damn well that he just laid out the case for multiple violations of the statute. The standard really isn't that high. I mean, gross negligence, under that is negligence. It's not intent. It's not even material knowledge or material violations or anything. It's gross negligence, which is a fairly low standard, and he knows it. And he lays out this case, point by point by point by point. And let me make it clear. The men and women of the FBI are good, strong, honorable patriots. They're the ones who laid out this case. They're the ones who pulled this all together. They're the ones who had to put together what Hillary Clinton and the gang unraveled and so forth. They're the ones, they're the forensic experts who day in and day out are doing the job, not him. He's sitting there as a political appointee trying to figure out, in this case, how to protect Hillary Clinton. Yes, he did. Yes, he did. And so did the Attorney General of the United States when she met with Bill Clinton. Don't tell me they met for 20 or 30 minutes to talk about their grandchildren. That's a joke. You can do that over the phone. You don't need to do it on a tarmac on a plane. Go ahead.
no reasonable prosecutor would bring such a case.
No reasonable prosecutor would bring such a case? Really? So only an unreasonable prosecutor would pull all this together. Let's pretend it's not Hillary Clinton. Let's pretend it's Ernie Grabotsky. Ernie Grabotsky, some schlub who's a GS-13 at the Department of Agriculture, and he's getting access to classified information. And Ernie Grabotsky decides, you know what? I'm going to have not one, maybe 3, maybe 4 private servers. I'll put them in my home. I'll get information. What the hell? Then I'll have my lawyers clean the damn thing out. That's personal. Get rid of it. Clean it. And then we'll only give certain things to the FBI. Now, does anybody on the face of this planet believe that Ernie Grabotsky wouldn't be charged? Now, of course he would be. Not only that, look at the timing of this thing. She wins the primary. She's now the putative nominee of the Democrat Party. Barack Obama has announced that he's going to go on a campaign trip with her today. He's well aware of this. He knows damn well the Attorney General and Bill Clinton met last week in Phoenix on the tarmac. He knows exactly what's going on. Nobody has to tell him. So meanwhile, his staff, the FBI, the investigators out there, pull all this together. They come to Comey and they go, look what the hell we found. And then the politics kicks in. This is completely rigged. There's absolutely no question in my mind. I am telling you, as a former chief of staff to an Attorney General of the United States, this isn't even a close case. What does he mean a reasonable prosecutor wouldn't take this case? Are you kidding me? Look at the prosecutor who went after the former governor of Virginia, McDonnell. That guy didn't do a damn thing. All he did was introduce somebody to somebody else to hold a meeting. A quid pro, that's the quo, quid pro quo. Even the Supreme Court, 8-0, said no. Is that a reasonable prosecutor? I think a reasonable prosecutor with this information would essentially have an open and shut case, to be honest with you. Hillary Clinton, always skating on the edge, always. Whether it's Whitewater and everything in between, always skating on the edge, always protected, and damn it, she might be the next president of the United States. And then what happens? Utterly lawless. Go ahead.
Prosecutors necessarily weigh a number of factors before deciding whether to bring charges. There are obvious considerations like the strength of the evidence.
Let me tell you something. He's going beyond doing a no recommendation here, a no charge, a no bill. He's now acting as a special pleader for Hillary Clinton. Is he not? Now he's telling you what prosecutors weigh, and no reasonable prosecutor would bring this case. He's now telling the prosecutors at the Justice Department, don't bring the case. He's gone beyond being passive about it or suggesting a no bill, no indictment. What he's doing now is saying, by the way, you prosecutors over there, no reasonable prosecutor would bring this case. This is how you should analyze it, and the answer is no. This guy's in hook, line, and sinker. Go ahead.
Especially regarding intent. Responsible decisions also consider the context of a person's actions and how similar situations have been handled in the past.
Stop. Well, can you give us a similar situation where a cabinet official had several private servers, where they violated the Espionage Act serially, where they went to hostile territory and used the private server and private email for communication, where it was accessed? Can you give us one name? Isn't that a little specious that we had on of a similar case? And then he says, well, I looked at the prosecutions, and of course, we've never brought a case like this. You've never had a case like this. Go ahead.
In looking back at our investigations into the mishandling or removal of classified information, we cannot find a case that would support bringing criminal charges on these facts. All the cases prosecuted involved some combination of clearly intentional and willful mishandling of classified information or vast quantities of information.
Stop. I thought the test was gross negligence. Now he's saying clearly intentional. So it's not even intentional. He's just changed the statute. It's gross negligence, not intentional, not clearly intentional. That's number one. Number two, he's talking about massive amounts of information. Well, what the hell is this? It's a lot of information, but massive amounts of information shouldn't be the issue. It's the fact that it's secret, and in some cases beyond secret. Go ahead.
Exposed in such a way as to support an inference of intentional misconduct or indications of disloyalty to the United States.
Okay,
or
stop.
efforts to...
Listen, folks, I was involved in gathering some of the information that would go to the criminal division from the U.S. Attorney's Office up to the Attorney General. A couple of these spies, I'm not going to get into them specifically. So nobody's talking about her being a spy under the Espionage Act. And you don't have to be a spy under the Espionage Act or, quote unquote, disloyal to the United States. That's a test, but it's not the test that applies here. The test that applies here is a rather simple one. Did Hillary Clinton do what she did intentionally? That's not the test, but she did. Look, here's my point. The consequences of her actions only build a stronger case. The fact of her actions is what the statute's covering. Did she do A, B, C? And in doing A, B, C, was she grossly negligent? That's the test. The answer is yes, 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 25 to 50 times. Go ahead.
Obstruct justice. We do not see those things here. To be clear, this is not to suggest that in similar circumstances,
listen to this.
a person who engaged in this activity would face no consequences.
Stop. This is not to suggest that any individual facing similar circumstances would face no consequences. What does that mean? What it means is if you're not Hillary Clinton and you do this, and you're senior executive service or a GS-15 or a GS-7 or whatever the government level you're employed at, we're going to throw the book at you. So he's saying, don't use this as precedent. He's talking out of both sides of his mouth. Don't use this as precedent. He's telling all the employees of the federal government and everybody else, particularly the Republicans, don't use this as precedent because we'll come at you and we'll charge you and you will do time. Go ahead.
To the contrary, those individuals are often subject to security or administrative sanctions, but that's not what we're deciding now. As a result, although the Department...
Wasn't that clever? What does that mean? Hillary Clinton will not be subject to the other things that people are subjected to also. In other words, they'd be fired, they might lose their pension, you know, they wouldn't have access to security. This is a lady who's running for president of the United States. This is how she treated the State Department. And then she gets up there and pretends that she's ignorant and illiterate about computers and stupid. Sounds like they knew what they were doing, right? Took the FBI a zillion hours and over a year to piece together what she took apart with her private servers and all the rest of it and her lawyers. And yeah, she did a pretty good job of undermining and evading federal law, didn't she? Go ahead.
Justice makes final decisions on matters like this, we are expressing to Justice our view that no charges are appropriate in this case.
Any questions?
I know there will be intense public debate in the wake of this recommendation, as there was throughout the investigation. Yeah. What I can assure the American people is that this investigation was done honestly, competently, and independently.
Stop. I don't doubt that for a second. Honestly, competently, and independently, I believe the investigation laid out the case to bring a bill, a charge, a list of indictable charges against Hillary Clinton. I don't even think this guy understands he made the case to indict Hillary Clinton. And then he walks it back. So nobody's doubting the men and women of the FBI. We're doubting you, pal. We're doubting you. Go ahead.
No outside influence of any kind was brought to bear. I know there were many opinions expressed by people who are not part of the investigation, including people
Let's
in
stop
government.
now. Why is he giving a political speech? Isn't he the FBI director? Why is he so defensive? Go ahead.
But none of that mattered to us. Opinions are irrelevant. And they were all uninformed by insight into our investigation because we did our investigation the
All right,
right
shut up
way.
already. None of this matters. All the money, all the time spent, all the details, all the information they gathered from a prosecutorial point of view, none of this matters. The private servers, the email, the security violations, the information that may have been revealed to the enemy, and everything in between, none of it matters. Because she's off scot-free. He just gave her a bill of health. He just put the FBI's imprimatur on it. It may have political consequences, no question about it, maybe not. But as a matter of law, the law is broken. It's rigged when it comes to Hillary Clinton. Nobody gets away with this. That's my experience. Nobody would get away with this. And yet, none of it matters, according to James Comey. That should be his legacy. That's how he should be remembered, no matter what he's done before or since. He's a complete and utter hack, in my opinion, despite the best efforts of some to tell us what a great professional he is. No, he's not.